Greetings, Rob Chassner here, and this recording is an answer to several clients who are working with foreclosure issues that had specific questions of what to do after they've gone through the administrative process. And so I'm going to deal with those on this video. And prior to dealing with that, I want to remind anyone who watches this video that if you are currently working with me, and even if you're not working with me and just watching this video, that there are terms and conditions, and this is a disclaimer with regard to Robert Chassner Consulting. We are an organization with a single mission. That mission is to educate and provide educational resources to those who want to understand the complexity of our commercial system and how it works. Rob Chassner is able to offer exclusive consulting, educational support, documentation, document resources, and continuing education sessions. Our goal is to educate people and for those people to become knowledgeable and independent so that they can solve their own problems. I assist and encourage those people through educational resources and document resources, and they, the client, are to take whatever those resources are to empower themselves and to take their own action. This is what empowers people to clearly and confidently explain their position rather than to to defend it. So Robert Chassner provides educational resources and assists consulting clients in developing the knowledge and confidence that our clients need to better understand and handle their own commercial affairs. The purpose of the consulting with Robert Chassner is to provide an opportunity to personally interact with Robert Chassner in an effort to aid with your own personal research and development. I, Robert Chassner, am not an attorney. I don't claim to be an attorney, and I do not give legal advice. I, Robert Chassner, also am not an accountant, and therefore I don't give any tax advice. Each person's situation is unique, and I cannot and do not guarantee any particular results or any outcomes regarding your specific situation. So the terms and conditions of working with me or with Rob Chassner Consulting, all opinions and information discussed or disseminated by me is for education and entertainment purposes only and does not reflect opinions or views of Robert Chassner. All information is interpreted and applied at your own risk. All consulting fees are prepaid at the time of service and are not refundable, nor are they transferable. All discussions, whether they're recorded or not, or other materials, including documents and videos, provided by Robert Chassner Consulting Services, including but not limited to emails, faxes, text messaging, and videos, documents, and so forth, are not to be redistributed. They're not to be shared without prior written consent by me, Robert Chassner. Any violation of that would be a violation of trust and constitutes an injury against me, Robert Chassner, and would be subject to termination of those consulting services. As previously stated, services offered by Robert Chassner are for educational purposes only, and any information discussed therein is to be applied by you, the ones who are listening, hearing, watching, or using this education. You're applying it at your own risk. And as such, you are agreeing just by using or listening to this information, this education, or any of the resources I provide, constitutes your agreement to indemnify and to hold harmless Robert Chassner Consulting, me, and any staff members that I have against any and all liabilities, damages, costs, and expenses, including lawyer fees, attorney fees, and related disbursements, arising from the use or the application or the dissemination of any and all information discussed, shared by me, by Robert Chassner Consulting. By watching or listening to this video, you are hereby acknowledging and accepting the terms that I have just outlined in the past 6 minutes on this video, and constitutes an agreement thereof. All right, having said all of that, the purpose of this particular educational video is to discuss what are the next steps in defending your position on a foreclosure or against a foreclosure. And so the presumption in this discussion would be that you have gone through a full and complete administrative process where you have satisfied the obligation with legal tender. You have submitted to the alleged lender an affidavit of zero balance, given them a first, a second, and a final chance to refute or rebut your affidavit of zero balance. You certify their non-response and their non-performance with affidavits, and now you have a notice of default and consent to judgment, and you likely also have an estoppel after that complete process, which is a document which says that they no longer can attempt to collect or foreclose against you on the property. Now, if you don't have an estoppel, that would be a document of importance, and you're welcome to call or email me to get an example of what an estoppel notice would look like. Now, once all of that is finished, and under the presumption that the bank is still attempting to take your house through a foreclosure process, there are a number of things that one can consider doing. And so, if there's not a foreclosure going on, or well, let me rephrase that. If a foreclosure has not already been granted by the court, then one might file a counterclaim against the bank and bring forth the evidence of the administrative process that I just outlined over the past 2 or 3 minutes of the tendered instruments and the affidavits that are unrebutted of zero balance, and bring forth those into a counterclaim, and then do a show cause, bringing the opposing parties and swearing them in under penalty of perjury, and make them swear that money is still owed, or make them swear under penalty of perjury that the instruments that you tendered are not sufficient to settle, set off, and discharge any obligations that they claim against you or your home. Now, the presumption also, if a foreclosure has been granted through the court system in favor of the court, one might consider that judgment by the court as a contract offer. Now, what does that mean? A judgment is a contract offer. And the reason why judgments stand, most of them that are issued by the court, in my opinion, is because nobody objects to those judgments. There's ways to void a judgment. There's ways to conditionally accept a judgment and go back and make the judge prove that the judgment was a valid judgment and that he did it properly. Now, if you have an affidavit of an unrebutted affidavit of zero balance, and you have evidence that you have tendered full and complete settlement, set off, and discharge of the obligation, there's no reason for a court to be issuing a judgment to take the collateral, the house. And so therefore, if a judgment is issued, one could then on the private side go to the real living party, the living being who's acting as a judge. You can go to the attorney, the real living being who's acting as the attorney for the bank. You can go to the CFO or the CEO or the president of the real living being who is acting as the CFO or the CEO or the president of the bank, and you could go to all of them on the private side and make all of them respondents to your conditional acceptance, jointly and severally, corporately and personally. You make them personally liable for the choices that they're making, and you demand that they swear under penalty of perjury that you have not tendered full and complete settlement of the obligation. Make them swear under penalty of perjury using an affidavit, making them fully liable for what they're saying, that they can justify this judgment, that you do not have an unrebutted affidavit of zero balance. So conditional acceptances, so I conditionally accept your offer to foreclose upon proof of claim that, and then you make a list. Proof of claim that I have not tendered sufficient or legal tender for the full and complete settlement, set off, and discharge of the account. Proof of claim that I do not have an unrebutted affidavit of zero balance that has not been challenged by the opposing parties, which would be the bank or the bank's attorneys, and make them personally liable for that. Now, in my experience, I've never seen them come back. Anybody, attorneys, judges, bankers, nobody has ever come back swearing under penalty of perjury to prove their claim. And so in a constructive notice of conditional acceptance, I also attach to it a commercial affidavit where I say that I'm of legal age, of sound mind, and if called upon would testify the veracity of my statements. And then I take all of those requirements that I demanded that they prove, and I put them in a format of an affidavit of specific negative averments. In other words, there is no evidence that the affiant did not tender full and complete settlement, set off, and discharge of account so-and-so or case so-and-so, and the affiant believes no such evidence exists. There is no evidence that John Doe banker swore under penalty of perjury refuting my affidavit of zero balance, and the affiant believes no such evidence exists, and so forth and so on. And you demand that they answer within a specific period of time, and that they answer in an affidavit format swearing under penalty of perjury. And what happens is, in that contract offer, you say if you don't answer, your non-response constitutes agreement to my claims. And that my claim is that the account has a zero balance, and that the account has been settled in full, and that you're granting me specific power of attorney to mark the public record straight on this account, and so forth and so on. And so that's how you can handle a judgment. A judgment's a contract offer. Well, if you don't do anything about it, the judgment stands. But if you decline the judgment, that's dishonorable. But if you conditionally accept the judgment upon proof of claim, that's staying in honor. Now they have to prove their claim, and when they don't prove it, and I don't say if they don't prove it, when they don't prove it, they are then going to go into default. So you have to follow up with a full administrative process after that constructive notice of conditional acceptance, and you have to follow up with an affidavit of non-response, and you have to follow up with a notice of fault and opportunity to cure, giving them a second chance to answer, and when they don't, then you follow up with a notice of default and consent to judgment, and an estoppel notice once again, and then you estop the judgment. All right, so that's a strategy that one could consider, and that's something that I've used successfully. Now, alternatively, or in addition to, that would be your choice, how much paperwork you want to do and how strong you want to make your case. But if there's not been a foreclosure, you can do a counterclaim. But if there has been a foreclosure, then you can do a new claim. You can file, in my opinion, if you've done all of that administrative stuff and you have an administrative judgment, you wouldn't want to file a complaint because the judge would look and say, well, you already have an administrative judgment. Why are you filing a lawsuit? Because you already have that administrative judgment. So in my opinion, you'd want to file an amended complaint. And what the amended complaint would do would be to attach your evidence that you've set off the account, your evidence that you have an unrebutted affidavit of zero balance, and that your evidence that you have an administrative judgment of a zero balance, and then you file an amended complaint, and you ask the court to review your administrative judgment and ratify your administrative judgment with a judicial judgment. The word ratify means to agree with. So you ask the judge to agree with your administrative judgment by issuing a judicial judgment. Then, if you have a favorable judgment in other words, if he or she agrees with that, then you can move the court to mark the public record, or to enforce that the bank marks the public record to zero balance, that the bank remove the lien from the property, that the bank reconvey title to you as the proper owner, and that the bank cancel the trust that holds the mortgage that's filed into the public record. And so that would be called an amended complaint. And if you got a favorable judgment using an amended complaint, rather than you having to do all the dirty work, you can just move the court, and the judge will do the dirty work for you of getting your property back. Now, the one final thing is if a home is taken, if the collateral is taken, and you were not in time or were not effective with your administrative procedures taking them into the court, and you still have the evidence that you paid the account, you still have evidence of an unrebutted affidavit, and then now you have the new evidence that the bank stole your property, in my opinion, I think that an action, in other words, a lawsuit or an action in recoupment would be in order, that someone could consider, where they bring all of their evidence into a new court case and moving the court to a judgment, a declaratory or default judgment. I think it would be a declaratory judgment, but nevertheless it would be some kind of a judgment in favor of you, that you paid the obligation, you had an unrebutted affidavit of zero balance, and yet they still stole your property. They took the collateral away, and you're moving the court to have to enforce, after a judgment, to enforce that the bank write you a check for the value of what you placed on that property, of what you paid on the set-off package and so forth, maybe all of the payments you made, all the costs that you've managed the property, your principal, interest, taxes, insurance, maintenance, and repairs, and you can put all of that in the complaint and ask the judge to issue a judgment to enforce that the bank write you a check for the property or the collateral that they took. And so, as an alternative, to give you back the property free and clear, or and then you could add to that any other fees that the court deems necessary. All right, so those are the few options that I personally would consider in a foreclosure case. I've used many of those documents successfully to enforce the administrative process by bringing it into the judicial system. And all of that is done biblically. If you read Matthew chapter 18, verses 15, 16, and 17, it's very clear. Matthew 18:15 can be interpreted as the administrative process that you first do, which would be the going directly to your brother in commerce and settling the account. If they don't give you the collateral, Matthew 18:16 talks about going back with 2 witnesses, and so that might be a notary protest or some kind of a third party protesting that they have not honored your set-off package. And then Matthew 18:17 could be interpreted, where it says treat them like a tax assessor. That would be where you take your administrative process and you bring it into the court system. That would be my interpretation of Matthew 18:17, would be to then bring it into the public side. And you could do so with a counterclaim. You could do so with an amended complaint. You could do so with an action recoupment. All right. Again, I hope that this information has been helpful and informative. Thank you for viewing. If you have questions or comments, or if you would like to have sample documents on any of the procedures which I have referenced, you are welcome to contact me. Again, thank you for viewing, and good day.